Hey guys, I'm going to try to make sure I can get some of these chapter reviews or the reading reviews done for you. And this is for the pre-work agenda, and it starts by having us look at pages. I'm looking at my agenda over here, right? Pages 9 through 12, chapters 11, 12, and 15. And I'll try to do this all in one video. So if you look on page 9, part of the reason I wanted you to just review 9 through 12 in particular to start us off with is because a lot of what happens, a lot of times people think labor law or management and employee relations are all about hurting the employer. It's really not, but management does make mistakes and then you have to pay for that, right? So this gives us a little bit of an idea by just introducing us to one of the cases, and this book is littered with cases. And what it boiled down to, and as you read through this, it costs them $382,120 in compensatory damages and then an additional $50,000 in punitive damages. When they talk about punitive, it means that the court might award you additional damages if they feel that the complaint or what was done to them was especially damaging, or they feel that it just wasn't enough in the compensatory for. That's where you hear like the phrase pain and suffering that might get tacked on to this. So this was a very expensive mistake by making a promise that you didn't keep, right? As it goes forward, talks a little bit about future lawsuits and things like that. What you really need to take from this is that you do have to be mindful of the laws. We don't get to say or do whatever we want. An at-will employer, the at-will employment doctrine is not a law. It's a doctrine or a guiding light sort of thing, but it's not going to excuse a mistake that might cost you if you have discriminated someone in the workplace. And then in chapter 11, if you fast forward and grab your book here and go to chapter 11, this just introduces us to like the four main labor laws. And this is the National Labor Relations Act, the Labor Management Relations Act, the Fair Labor Standards Act, and then the Labor Management Reporting and Disclosure Act. I'm not going to read all of this to you. That's very brief information. You can read what they cover and what they're for. The Fair Labor and Standards Act on page 235, that's where this is basically what we would call the Wage and Hour Act. And if you look at the Labor Management Reporting and Disclosure Act, if you look at the Fair Labor Standards Act, number 3 on page 235, they talk about exempt employees, and be mindful that those are just words to refer to a salaried employee versus a non-exempt, who is someone who's paid hourly, okay? Because there's guidelines in how these need to be handled legally, okay? Let's see. If you look on page 237, here again talking about the Fair Labor and Standards Act. They talk a little bit about gender, and we'll talk more about this when we get to the sexual harassment area a little bit. And this, because it's from the legal perspective, it's talking a little, we look at the harassment part of this. But as far as disparage pay, gender has always been a huge area of concern. We don't have pay for performance in this country. We don't. Equal pay for performance. It's a theory. It's a guideline. We're working towards it. If your company professes that they have equal pay for performance, they have to prove it. You can't, they note here, for example, you cannot simply lower the wage rate of any employee just to end a wage disparity and things like that. So be mindful of how these laws affect your pay decisions, and oh my gosh, and pay increases and things like that. And then every chapter you're going to learn as you do go through the reading here has a what you can do and what you can't do. So I love this about this book. It's why this is an older book. So believe me too, when you read things in the book, it talks about something that happened or has been revamped. This is like the updated in 2004. And believe me, we've considered getting rid of this book, but it's just it's so insightful. You don't need to know, and we do a lot of current events in it, but you don't need to know every law change, because if you're not working HR, you're not going to follow this kind of stuff. But what you can do and what you can't do, most of the time, that's pretty much the same as it has been for a while. And then Oh, on page 239, I have in my notes on my book, I highlight and just basically wreck my books because I use them like my notebook. I thought it was interesting on the bottom of page 239, they were talking about the Labor Management Relations Act of 1947, preventing wildcat strikes or unwarranted lockouts. That generally that ends up in a mediators type table to work this out. Um, and if there's a general threat to the welfare of the general public, that's what some of this is for. Like, for example, air traffic controllers not allowing certain agents or certain groups to strike in the same way. Again, exempt employees are mentioned on page 240, and that's talking about salaried positions. This is a huge deal today. Today, fast forward, 2004, fast forward. Now, we have salaried and we have hourly employees, right? But we have this whole issue of subcontracted employees. So the IT industry, that really is the industry that started all of this. That really, I said, hit the news, not started all of it, but really hit the news where we started to realize, and that's where on page 241, they talk about docking, like for salaried employees getting docked for taking time off, like to go to the doctor. It's like, well, we don't have to pay you extra because you're on salary, right? And even though you work over 40 hours a week, we don't have to pay you extra. So be very, very mindful when you're, oh, there's my cocoa bean. That's my big dog. What? Yeah, there was a squirrel on the deck. She was very worked up about it not 10 minutes ago. Anyway, so this gives you an idea of what it means to dock a salaried employee and be very, very careful about that. And that's why companies are very clear about how they designate whether you are an exempt or non-exempt employee. Casebooks, I'm not going to go through these. You should be reading these at the end, and we use some of them throughout the class as part of our work. And then chapter 12, page 246, the Uniform Services Employment and Reemployment Rights Act of 1994. Say that 3 times really super duper fast, right? This is much more in the forefront. I mean, when this was 1994, think how long and how many wars we've been in since then. Think Iraq and Afghanistan and all of that. This has taken on much more of an important role when it comes to hiring and firing within the workplace. So they tell us the purpose of it, right? Encourage non-career service, minimize the disruption to the lives of persons performing services, prohibit the discrimination of those folks, and then prohibit discrimination. Well, they have 2 delineations: prohibit the discrimination of anyone because of his or her service in their uniform services. Oh my gosh, say that 99 times. Meaning that some people, if you disagree with a war or you disagree with whatever it is, that you might discriminate just based on the fact that they served. Prohibiting discrimination when the employee's military status was a motivating factor, even though it was not the sole factor in the action. So again, this is just to help those that have, because there was need for this. Believe it or not, military personnel do get discriminated against. You can read on who it protects, what the employees must do, what the responsibility is of the employee, because it works both ways. What you can and cannot do is pretty straightforward, and that's about it. Then it'll go to the case book. That's why it seemed like a lot of reading, but these chapters are pretty small. And then the last chapter, chapter 15, I won't spend a whole bunch of time here because the reduction in workforce, the RIFs, you are going to be doing that as part of an interview assignment. But basically, the Warren Act of 1989 was really instrumental in helping people understand this whole idea, like, what is the fairest way when we have to reduce our labor force, right? Now, a lot of people go, oh, you mean firing? Not necessarily. When you look on page 299, this could be mergers and acquisitions have a huge impact on the workforce. Downsizing, buyouts, layoffs, right sizing, lots of terms. It kind of goes in business cycles on which term we use. But there's certain ways that you need to do that so that it's fair and legal. And you can read that. They start with on page 229, to protect yourself and the company. They list 9 different things that you should be aware of. Now, if you work in HR and when you do your interview, you should be working with an HR person. This is what they live. This is what they do. They'll understand this. But I do ask you to reflect on the Warren Act. Let me see. that's pretty basic stuff. 300 to 301, what you need to be mindful of. Effects of the WARN Act. On page 303, realistic effects of waivers. This is interesting because everybody seems to think that once you sign a waiver, like all your rights are gone. Not true. Not true. However, it's noted here on page 303. However, if you ask an employee to waive his or her right to sue the company for discrimination or any other negative reason, make sure that you have all your bases covered, because that's not necessarily going to be the truth. It says, in fact, in the spring of 97, the Equal Employment Opportunity Commission, the EEOC, stated that an employee's promises not to file a discrimination lawsuit is null and void as far as the commission is concerned, and still is, by the way. Agreements extracting such promises from employees may also amount to separate and discrete violations of the anti-retaliation provisions of the Civil Rights Status. The Civil Rights Act overrides all of that, right? It says, and I highlighted it here, a waiver may prevent an individual from suing. This, the EEOC notice says, but it doesn't prevent the commission from enforcing the ADEA and any other law that prohibits employment discrimination. And then remember, on top of this too, we have state laws. Federal will always override state, but we have to be mindful that there are state laws. So that basically walks us through the reading that's part of our pre-work. And I'll see you back for the next reading section if I can get some time in, right?